I was asked to make a few remarks and also touch on my thoughts on how Kenya has attempted to domesticate the Rome Statute. Kenya acceded the Rome Statute in 2005. And 2 years later, we had probably one of the worst of the many post-election violence incidents in this country, and that was 2007, 2008, a very dark moment for this country. Prior to that, it was common in Kenya that every 5 years, prior to an election, during an election, or post an election, we would have violence. The other week, I was looking at old cases that our High Court has handled over the years. And interestingly, Kenya has moved away from election disputes based on pre-election violence or election violence during an election. Today, our cases, our petitions around an election are more related to technology. For example, in 2017, the presidential election petition in which I sat, in 2 of them, the main issue was transmission of election results. In 2022, again, the issue was transmission of results. But Kenya is still steeped in that cycle of post-election violence. So that we have not moved away from violence totally, and therefore, the question we must ask ourselves is this: how much then does the Rome Statute mean in Kenya? And is Kenya capable of investigating, prosecuting, and punishing core international crimes such as genocide, crimes against humanity, and war crimes? Give it to Kenya. We now have the International Crimes Act, which is something a lot of countries don't have. But that was 17 years ago when we enacted that act. And again, it was a product of the post-election violence of 2007. And the question, again, we must ask is this: does that act have any real meaning to Kenya? It is a statute in our books, or is it a statute that has purpose, that has meaning? A few years back, in an attempt to give it some legitimacy, a conversation was begun in Kenya about creating an international crimes division of the High Court. Bettina and I and others were deeply involved in that conversation. At the time, I was a member of the Judicial Service Commission, which was the commission that was detailed to create that division. It is not a story for today, but we all know that division has now been created. And why are we not doing that? Last week, we had a new division created by the Chief Justice, and nobody is talking about this division yet. And that then takes me to the context in which our reluctance as a country must be understood. In 2017, the Supreme Court nullified the presidential election. And we ordered a repeat of the election in October of that year. And then post-election violence, like I said, commenced. And a child was killed in Kisumu by the police. And that is the story that we have. But it only took this last year for the alleged perpetrators to be taken to court. And the question we must ask ourselves is, will Baby Pendo, will that case address some of the pertinent issues arising from the application of the International Crimes Act? Is this a good test case for the prosecutor here, for the judge hearing the case, for the defense, to bring to the fore the applicability of the International Crimes Act? And I'm expecting myself, sitting from where I sit, and without discussing at all the merits or demerits of that case, that some of the questions that are important for that court to address, and I believe my brother, the prosecutor, will have to address, are the following. what are the parameters of command responsibility? How should it be proved for criminal culpability to attach where the accused persons are charged both individually and collectively? Crimes are committed generally by individuals, and you cannot translate in common law parlance the actus reus beyond the individual. But here we are saying that these policemen were acting under the command of a superior. How will the court treat that question? What are the elements in this case of the superior and subordinate relationship, and how will the Akayesu case at the ICTR and the Katanga case at the ICC be applicable to this Baby Pendo case? Number two, the accused persons, one I'm told has fled to Somalia, are charged with murder as a crime against humanity, contrary to sections 3A, 63A and 71A of the ICA, as read in Article 28 of the Rome Statute. They are also charged with rape and torture, contrary to section 6.1 of the International Crimes Act. And the question then is, what is the proof in the context of the case around these crimes? Remember, it is a test case that must set the law for Kenya. And we can lose an opportunity if the prosecution doesn't step up and bring to the fore answers to these questions. We may lose the opportunity if the defense does not step up. We may lose the opportunity if we in the judiciary do not step up. Because this case may well go all the way up to the Court of Appeal and perhaps to my court. And then what shall we say about the Rome Statute, the International Crimes Act, and this brand new case that is testing all these parameters? The Baby Pendo case relates more to do with the very unfortunate death of Baby Pendo. But in looking at an international crime and crimes against humanity, murder as a crime against humanity, where do questions around attacks against civilians? Because at the time that these things were happening in Kisumu, Kisumu was literally burning. The whole city was in chaos. Where do these questions arise? Mass attacks, widespread attacks, systemic attacks. This is the language of both the Rome Statute and the International Crimes Act. How does it then play out in a case such as this one? And as we also look at this case, we must look at the wider picture. And the wider picture is this. Has Kenya as a country and all its agencies, have we accepted the application of the Rome Statute to our issues? For many years, we have taken the ICC, because of the Kenyan situation cases, to be a foreign court. It is an intrusive court. It is a court that is coming here to punish us. But we now have systems. We have our complementary mechanism. We have our act. What are we doing about it to stem what I said is a persistent pattern of post-election violence? And yet, we are a part of the international community. We acceded to the treaty. We acceded to what it says. Can we run away from it? When I was at the East African Court of Justice for 7 years and the ICC cases started, there was a move to give the East African Court of Justice expanded jurisdiction to try international crimes. Is that the way to go? What does that speak to us when you have a statute which could do that without us going elsewhere? Is our judiciary prepared to handle these cases? Is our prosecution prepared? Is our investigative agencies prepared? Are we prepared to look at these cases and to look at the act through the necessity and the prism of the rule of law? And a remembrance that Kenyans have lost lives over the years, systematically, periodically, every 5 years. And we know some of the politicians who are party to this action. To our credit as a country, the ICC, Kenyan cases, has acted as a deterrence to a lot of people who otherwise would have used violence to achieve their nefarious political ends. But we must also continue to strengthen our legal framework.
2 minutes.
Yes. Is the Like I said, she keeps time like I do. Is the International Crimes Act sufficient? Have we given public awareness sufficient attention? Have we organized our people properly to be ready for this? And so I say to those who are here, learn from Kenya. Whether you're Sudanese or South Sudanese or South African, learn from Kenya. Kenya has had a checkered history. Good things have happened, bad things have happened. What are the lessons we can learn? And how can this case be useful to us? To you, my friends in civil society, today my senior brother, Chief Justice Emeritus Chande, spoke about networks, cooperation, collaboration. You in civil society must continue to remain strong and vibrant. You must continue to bring strategic litigation to us, to trigger jurisprudence in us. Judges cannot write good judgments unless you get good cases brought to us, and you, civil society, can do that. And let us build universal jurisdiction into our processes, because we are not. And that can only be done if we work together. And second last, let us not miss opportunities to bring potential international crimes under the International Crimes Act, because only then can the bounds of jurisprudence, the bounds of law, and the parameters of law be tested sufficiently for us to be happy that they work. Lastly, when I last spoke about this subject to prosecutors at their training college, I spoke about passion. I spoke about boldness. I spoke about lack of timidity. I spoke about the need for us in these professions that are around these cases to continuously be bold, to continuously have passion. If for nothing else than the lives of those we have lost over the years should have meaning in what we do today, never to have cases like this. I thank you very much.